"May I have your badge number in the name of your supervisor?" The words were calm, measured, the kind of tone that belonged in a federal courtroom, not in the middle of an airport security line at 7:30 in the morning. The kind of tone that came from someone who had spent decades in rooms where powerful people tried to make her feel small, and had learned through sheer repetition that silence and stillness were more devastating than any raised voice could ever be. Officer Thomas Garrett heard the question and laughed. Not a nervous laugh. Not a laugh that suggested any uncertainty whatsoever. It was the laugh of a man who had been asked that question before by people he considered beneath him, and who had learned over 17 years that the laugh alone was usually enough to make them back down. He reached for his radio. "I need backup at pre-check lane 4, non-compliant passenger, possibly hostile." The woman standing in front of him did not flinch. She did not step back. She simply waited, her leather briefcase held at her side, her navy suit immaculate. Her eyes steady in the way that eyes become steady when they have witnessed things that cannot be unseen and survived things that cannot be undone. What Officer Thomas Garrett did not know, what he had not bothered to find out before he planted himself in her path and began this particular performance, would have stopped him cold. He did not know that the woman standing before him had spent 24 years as a federal prosecutor before ascending to one of the most powerful judicial appointments in the country. He did not know that she had personally sent 19 police officers to federal prison, not for dramatic crimes, but for the quiet, institutional kind of abuse that gets covered up in incident reports and dismissed at internal affairs hearings. He did not know that her written opinions had reshaped civil rights law in 7 states, that her name appeared in law school textbooks, that she had been confirmed to the federal bench by 91 United States senators because even people who disagreed on almost everything agreed that she was the real thing. He did not know that she had spent her entire career making sure that people exactly like him faced consequences. He thought he was dealing with a civilian who didn't know her place. He was standing in front of the woman who had dedicated her life to ensuring that everyone had a place and that no badge could take it from them. 9 security cameras were running inside Hartsfield-Jackson Atlanta International Airport that morning, and every single one of them was pointed in the right direction. What they captured over the next 11 minutes would be viewed more than 48 million times. It would trigger an FBI investigation, result in federal indictments against 4 law enforcement officers, dismantle an entire airport police department, and produce one of the largest civil rights verdicts in the history of American aviation security. Thomas Garrett had done this kind of thing more than 36 times before and had never faced a single consequence. He had never done it to Renee Caldwell. Thomas Garrett was 43 years old, and 17 years of working airport security had shaped him into something that was less a police officer and more a man-shaped argument for accountability. His uniform was always pressed, always fitted slightly too tight across the shoulders in a way that suggested he wanted people to notice the size of him before they noticed anything else. His face ran naturally toward red, not from exertion, but from the low-grade simmering irritation of someone who treated every interaction as a potential challenge to his authority. His eyes were small and moved quickly the way eyes do when they are always looking for something to be wrong. He had been stationed near the pre-check and priority boarding lanes for the better part of a decade, and he had come to regard that stretch of terminal the way a landlord regards a building as his in some way that no organizational chart had ever formally authored, but that nobody had ever formally challenged either. His colleagues had a nickname for him. They called him the toll booth. It was not a compliment from the people who understood exactly what it meant. In 17 years with the Atlanta Airport Police Department, Thomas Garrett had accumulated 34 formal complaints from travelers. 29 of those complaints came from black passengers or passengers of color. He had been accused of racial profiling, unlawful detention, verbal abuse, and excessive force so many times that the stack of paperwork would have filled a filing cabinet drawer if anyone had ever bothered to keep it organized in a way that suggested it mattered. None of it had ever touched him. There was Dr. Leonard Abrams, a black cardiothoracic surgeon traveling to a medical conference in Boston in the fall of 2019. Garrett detained him for 3 hours in a private screening room based on what the incident report later described as a suspicious behavioral profile. Dr. Abrams missed his connecting flight, missed the opening session of the conference, and missed a phone call from a colleague about a patient who was deteriorating faster than expected. He filed a complaint the following week. It was dismissed within 30 days as lacking sufficient evidence of discriminatory intent. There was Pauline Graham, a black elementary school teacher chaperoning a class field trip to Washington, D.C. Garrett pulled her out of the pre-check line in front of 22 of her students ages 9 and 10 and took her to a private room for what he called enhanced secondary screening. Her students waited in the terminal for 40 minutes without their teacher. She filed a complaint. It was dismissed. There was James Whitfield, a black Army veteran still wearing his unit sweatshirt when Garrett stopped him and spent 20 minutes demanding to know how he had obtained the garment and whether he was actually prior military. Whitfield had served 2 tours in Afghanistan. He filed a complaint. It was dismissed. Every single dismissal landed on the desk of Lieutenant Ray Hollis. Lieutenant Ray Hollis was 52 years old, and he was not a violent man in the way that Garrett was a violent man. He had never grabbed anyone's arm, never raised his voice above a bureaucratic murmur, never done anything that would have appeared clearly wrong on a security camera. He was the kind of corrupt that is far more durable than the obvious kind, the kind that wears the face of reasonable management and does its damage through inaction, through paperwork filed incorrectly, through phone calls, not returned through patterns noticed and deliberately ignored. He had promoted Garrett twice in 17 years, not because of any measurable excellence in policing, but because Garrett had never generated a complaint large enough that it could not be quietly smothered before reaching anyone who might actually do something about it. There was also something else, something that investigators would eventually describe as an informal competition among a group of officers on the early morning shift. The officers called it the redirect count. Whoever managed to divert the most minority travelers away from the pre-check and priority boarding lanes during a single shift earned immunity from weekend assignments for the following week. It was treated as a game. Ray Hollis knew about it. Ray Hollis had never once said a word. The morning of October 14th, Thomas Garrett was wrapping up a double shift he had come in to cover for a colleague who had called in sick, which meant he had been awake for nearly 20 hours and was operating on the particular combination of exhaustion and resentment that tends to make bad judgment feel like good instinct. He was standing at his usual post near the pre-check entrance at the far end of the terminal, watching the morning rush build when he saw Renee Caldwell walk through the main concourse doors. Navy suit, leather briefcase, posture like someone who had never once in her life apologized for taking up space. He made his decision in under 3 seconds. He had not yet looked at her credentials. He had not yet heard her name. He had looked at her face and decided in the way that 17 years of zero accountability had taught him to decide that she needed to be checked. Renee Caldwell was born and raised in Greenville, South Carolina, in a part of the city that sat on the less photographed side of the economic divide, the side where the textile mills were, where the houses got smaller, the further east you went where the streetlights flickered and nobody from the west side of town ever had much reason to visit. Her father, Earl Caldwell, was an electrician. He had worked for that same commercial property company for 22 years, shown up on time every single day, never received a negative performance review, and was passed over for a supervisory position, 4 times each time in favor of men who were younger and less experienced, and who had one thing he didn't have, a thing that was never mentioned in the rejection letters, but that Renee understood by the time she was 10 years old. Her mother, Gloria, taught 3rd grade at the local elementary school for 31 years, at a salary that never kept pace with the cost of anything. She brought stacks of papers home every evening to grade at the kitchen table under the yellow overhead light, and she did it without complaint, because she had decided long ago that the work mattered, even when the recognition didn't. What Gloria told Renee not once, but as a kind of steady drumbeat throughout her childhood, repeated in the car on the way to school, and at the dinner table and in the doorway, when Renee was leaving for somewhere, was this: the one thing no one can ever take from you is what you know. Put everything you have into what you know. Renee had been sitting under the kitchen light one evening, maybe 11 years old, doing algebra homework while her parents watched the evening news when a segment came on about a civil rights attorney who had just won a discrimination case against a city government in Alabama. Her mother looked at the screen and then looked at Renee and didn't say anything, just looked, and that look had carried more information than most speeches ever did. She did not go to Harvard for her undergraduate degree. She did not go to any school whose name would have impressed the parents of her classmates because there were no scholarships large enough coming from where she was coming from for the schools whose names impressed people. She went to a state university in South Carolina on an academic scholarship that covered tuition, but not books, not housing, not the thousand small costs that nobody mentions in the financial aid package. She worked 20 hours a week her entire undergraduate career, made Dean's List every semester, and graduated in 3.5 years. Law school was harder and lonelier in ways she had not fully anticipated. She was in her first-year class at the University of Virginia School of Law, the only black woman in the Monday morning section. Her civil procedure professor had a habit of calling on students alphabetically at the start of each class. Caldwell came early in the alphabet. But somehow she was always called last, a pattern so consistent across a full semester that she had begun to wonder whether it was conscious or simply the unremarkable reflex of a man who had spent 40 years looking past certain people without noticing he was doing it. She kept raising her hand. She answered every question with the precision of someone who had decided that if she was going to be seen last, she would be remembered longest. One afternoon, a professor she had respected pulled her aside after class and told her in a tone meant to sound helpful that she might want to consider county-level prosecution rather than federal work. It would be more realistic, he said, given the competitive nature of federal placements and the fact that she did not have family connections in Washington. She thanked him. She went home. She applied for a federal internship at the U.S. Attorney's Office the following morning, and she got it. The first major case Renee Caldwell ever prosecuted on her own was not the kind of case that made the front page of national newspapers, but it was the kind that changed something permanent in a community that had been told for a long time that certain things could not be changed. A police officer in a small Georgia county had beaten a 23-year-old black man named Calvin Price during a traffic stop, and Calvin Price had died in a hospital 2 days later from injuries the county coroner had initially classified as resulting from a pre-existing condition. The local DA had declined to prosecute. The state AG had declined to get involved. Calvin Price's mother had driven 4 hours to Atlanta to sit in a federal building waiting room until someone agreed to talk to her. Renee took the case. She worked it for 14 months. She stood in front of a federal jury for 3 weeks, 8 hours a day, and she put a photograph of Calvin Price on the corner of her table every morning before the jury came in. Not as a legal strategy, but as a reminder to herself of who she was there for when the work became exhausting. The officer was convicted and sentenced to 11 years in federal prison. It was the first time in the history of that county that a law enforcement officer had been convicted for the death of a black civilian. Afterward, Calvin's mother found Renee in the corridor outside the courtroom and held her hands for a long moment without saying anything. Then she said, "You didn't promise me you'd win. You just promised you wouldn't stop. That's all I needed." Renee had kept that sentence on a piece of paper on her desk for the next 24 years. The email from the office of the president arrived on a Tuesday evening in March while Renee was eating leftover pasta at her kitchen table and reading through a stack of case briefs. She saw the subject line, set down her fork, and read it once. Then again. Then a third time, not because she didn't understand it, but because she was allowing herself to feel the full weight of it before she let it become ordinary. She sat there for a while in the quiet of her kitchen alone, which was the way she had spent a great many of the important moments of her adult life, not out of loneliness, but out of the habit of stillness that her mother had modeled and that the law had reinforced. Then she picked up her phone and called Gloria. Her mother answered on the second ring the way she always did, as if she had been expecting the call. "Mama," Renee said, "I need you to hear something." There was a pause. The particular pause of a woman in her late 70s who had been waiting a very long time for a specific kind of news and was taking a moment to receive it properly. "Your daddy knew," Gloria said finally. Her voice was very quiet. "He always said it. He knew from when you were little." Earl Caldwell had been gone for 3 years. Renee sat in her kitchen for a long time after they hung up, not moving, just letting the silence hold everything it needed to hold. The morning of October 14th, Renee Caldwell was up at 5:15, which was normal, because she had not needed an alarm clock in 15 years. She made black coffee on the stovetop the way her mother had always made it, and she drank it at the kitchen table while reviewing a brief for the Supreme Court hearing she was traveling to Washington to attend a case involving voting access in 3 southern states, a case that had been delayed twice already and could not afford another delay. She packed her briefcase the night before, the way she always did before an important day. Documents organized by argument, judicial credentials in the front pocket and in the small interior zip compartment. A photograph of her father, taken at her law school graduation. He was wearing his Sunday suit and the expression of a man who had been waiting for this specific moment his entire life. She put on the navy suit. She wore the navy suit for the days that mattered. She called a car at 6:45 and arrived at the airport at 7:20. She had made this exact trip, same flight, same terminal, same pre-check lane 14 times in the past 18 months. She had never once been stopped. She did not bring a security detail. It was a domestic flight. It was a Tuesday morning. She was a federal judge in her own country. She did not yet know that this would be the morning everything she had built over a lifetime would be the only thing standing between her and someone who believed his badge was a permission slip. Hartsfield Jackson. Atlanta International Airport at 20 minutes past 7 on a Tuesday morning, in October, is one of the most ordinary places in America, which is partly what makes it so important as a setting for what happened next. It is a place of coffee and paper cups and rolling suitcases and children being carried by parents who haven't slept and business people walking with the accelerated, slightly anxious stride of people who are already running 3 minutes behind. It is a place of announcements overhead and the smell of Dunkin' Donuts and the low, steady roar of a building that is always at every hour moving. The pre-check security lane is shorter and faster than the regular line. It is by design. The lane for people who have already been vetted by the federal government, people who have submitted to background checks and fingerprinting and determined to pose a low enough security risk that they don't need to remove their shoes or unfold their laptops. 9 security cameras covered the area around pre-check lane 4 that morning. Every single one of them was recording when Thomas Garrett began walking toward Renee Caldwell. She came through the main concourse doors at 7:38, moving at the efficient, unhurried pace of someone who had been doing this long enough to know exactly how much time she had and exactly how to use it. Navy suit, leather briefcase, sensible heels, the kind of posture that doesn't announce itself, but that you notice anyway, the posture of a person who occupies space as a matter of settled fact, rather than something that requires ongoing negotiation with the world around her. Thomas Garrett saw her from approximately 15 feet away. He did not look at her boarding pass. He did not look at the pre-check indicator on her ticket. He did not look at any of the several visible signs that she was a verified traveler moving through the correct lane at the correct time in the correct manner. He looked at her face, and in the time it takes most people to finish a sentence, he had made a complete and unalterable decision about who she was and what she was doing there. Security camera. Number 3, positioned above the pre-check entrance and angled slightly downward, captured the moment he stopped his conversation mid-sentence and began moving toward her. 2 white travelers behind her in the same lane were waved through without a glance. Standing a few feet to Garrett's left was Danny Mercer, 26 years old, 8 months into his first year on the force. He watched Garrett begin moving and felt the specific cold discomfort of a person who recognizes that something is about to go wrong but does not yet have the language or the courage to say so. Garrett stepped directly into her path, the way a person steps in front of someone when they want to make clear that stopping is not optional. His posture was wide-legged and settled, the posture of someone who had done this often enough that it had become physical vocabulary, a way of saying with his body that the next few minutes would be organized around his preferences. "Ma'am," he said, and the word landed without warmth or courtesy, laid flat like a hand on a table. "This lane is for verified travelers only. Regular screening is over there." He gestured toward the longer line without looking at it, his eyes staying on her face. Renee Caldwell stopped. She had been stopped like this before, not in this airport, not by this particular officer, but by the logic behind this particular move, which was a logic she understood in her bones. She reached into her briefcase and produced her credentials without haste, holding them out with the practiced steadiness of someone who had spent 24 years presenting evidence and knew that the key to the moment was not urgency. Camera number 3 recorded the full sequence credentials extended. Garrett's eyes moving to them. Garrett's eyes moving away. He did not take them. He did not scan them. He did not examine the federal seal, or the photograph, or the words printed in bold across the laminated surface. He looked at what she was holding long enough to see it, and then he looked back at her face and shook his head. "You're going to need additional screening," he said. In 24 years of federal prosecution and 9 years on the federal bench, Renee Caldwell had watched hundreds of hours of security camera footage from police encounters, and she knew with the analytical certainty of someone who had turned that footage into evidence and that evidence into verdicts exactly what she was looking at. She was looking at a man who had done this before, many times, confidently, with the ease of someone for whom this kind of behavior had never produced consequences significant enough to modify the behavior. She glanced up the way people do when they are thinking about something else and counted 4 cameras in her immediate line of sight. There were almost certainly more that she couldn't see from where she was standing. She made a decision that she would not fully describe in public until she was on the witness stand. 7 months later, she would not escalate. She would not explain herself beyond what was required, and she would give him as much time and as much rope as the cameras needed to capture everything he was willing to do. She had spent 2 decades arguing in courtrooms that the gap between what officers wrote in their reports and what cameras actually showed was the core problem in police accountability. She was not going to let this moment be decided by a report. She stepped out of line as instructed immediately, without protest, without even a pause that could later be called hesitation, and then she asked clearly and calmly and loudly enough for the recording equipment to pick up without any ambiguity for his badge number and the name of his supervisor. The request landed on Garrett the way that kind of request always landed on him, not as a reasonable exercise of a traveler's rights, but as an act of defiance that required immediate rebalancing. He reached for his radio and called for backup, describing Renee as non-compliant and possibly hostile. She had stepped out of line when he asked. She had kept her voice level. She had her hands visible at her sides. The only thing she had done that could by any reasonable interpretation be called non-compliant was ask him a question he didn't want to answer. "Hands on the wall," he said. "You're getting a pat-down." She asked on what grounds. It was a simple question. It was the right question. It was the question that any attorney, any citizen with a basic understanding of the Fourth Amendment, any person who had ever sat through a civics class would have asked in that exact moment. Because a pat-down requires a legal basis, and legal bases need to be stated. Garrett did not answer it. Instead, he stepped closer. Not the closing of distance between two people having a conversation, but the deliberate invasion of space that is designed to trigger the fear response to make someone step back to re-establish the physical hierarchy that her question had briefly disturbed. Around them, the ordinary morning airport had gone quiet in a 10-foot radius. A woman in her mid-40s had stopped walking and was standing very still. A man in a business suit had reached into his jacket pocket, not for a phone, not yet, but with the look of someone calculating whether the moment had arrived. Danny Mercer had been on the job for 8 months, which was long enough to understand how the culture worked and not yet long enough to have fully surrendered to it. He had grown up in Decatur, Georgia, gone to Georgia State on a partial scholarship, joined the airport police because a recruiter came to his college job fair, and the benefits were good, and he had thought with the specific idealism of someone who had not yet had it tested that keeping people safe sounded like meaningful work. 8 months with Thomas Garrett had done something to that idealism, not erased it but pushed it into a corner where it watched things happen and wasn't sure what it was allowed to do. He was watching now. He saw the credentials Renee had extended, had seen them clearly enough to make out the federal seal, the blue border, the words in large type across the face of the laminated card. He knew in the way that a person with functioning eyes and a functioning mind knows a thing what those credentials almost certainly said. He took a half step forward. "Garrett, maybe we should." Garrett cut him off without looking at him, a single dismissive word, and Mercer stopped moving. He would live with that stopped movement for a long time. Marcus Webb was 58 years old and had spent the better part of 3 decades practicing civil rights law in Atlanta, before his knees and his cardiologist together convinced him that retirement was not optional. He was traveling to his daughter's home in Philadelphia for her birthday, running slightly late carrying a carry-on and a garment bag, and he had been standing in the pre-check line long enough to have watched the entire exchange from the beginning. He pulled out his phone. He did not announce what he was doing. He did not ask permission. He simply raised the phone and began recording, positioning himself at an angle that would capture both Renee's face and Garrett's hands because he had spent enough years looking at evidence to know what angles mattered. On the other side of the security barrier, Sandra Ortiz, 44 years old, a high school English teacher from Marietta traveling to visit her sister, had also stopped. She had seen something like this happen to her brother 12 years ago in a different city in a different airport, and she had not had a phone in her hand then, and she had never forgiven herself for it. She had her phone out before Garrett's hand moved. Renee looked at Thomas Garrett with the particular quality of attention that she had developed over 2.5 decades of watching people in situations where they were either telling the truth or they were not, and she could see with complete clarity what kind of situation this was. She spoke clearly and at a volume that was neither shouting nor private, the specific calibration of someone who understood that the words needed to be heard by everyone in a 10-foot radius and recorded by anything capable of recording sound, because these words were going to matter, later in ways that this man did not yet understand. She identified herself as a federal circuit court judge. She stated that she had complied with every instruction. She stated that she was requesting his badge number and supervisor's name, as was her legal right. She stated all of this in the calm, sequential manner of a person constructing a record, because that is exactly what she was doing. Garrett's response was not a refusal exactly. It was something colder than a refusal. It was the response of a man who had already decided that whatever she said next, it would not change what he was about to do. He said something in the flat, dismissive register of a person for whom her words had not even fully registered as words, just as noise coming from someone who had not yet learned to be quiet when he told them to. The mask in that moment came all the way off. The cameras recorded every pixel of what it revealed underneath. There is a specific kind of human movement that tells you a decision has been made before the conscious mind has finished processing it. The slight forward lean of the torso. The hand rising from the belt, not to gesture, but to take the weight. Shifting to the front foot in the way that weight shifts before impact, rather than before communication. Renee saw it. She had 1 second, maybe 2, and she used them to say clearly and loudly enough for every microphone in the vicinity, "I am complying. My hands are visible. I am not resisting." Garrett's hand closed around her upper arm, not lightly. Not with the careful, measured contact of an officer conducting a lawful, controlled detention. His fingers wrapped around her arm above the elbow with a grip that security camera number 5 would later show in slow-motion court replay, applying pressure visible in the compression of the fabric of her sleeve. Around them, people had stopped entirely. Marcus Webb's phone was up and steady. Sandra Ortiz had moved 3 steps closer to get a better angle. A TSA officer 30 feet away had looked up from her workstation at the shift in the ambient noise of the terminal. Renee Caldwell's credentials were still open in her other hand. The photograph on the laminated surface was looking up at the ceiling. The federal seal was catching the overhead lights. Garrett had not looked at them. What happened in the next 8 seconds was captured from 4 separate camera angles, and the composite picture they produced, which would later be assembled by FBI forensic technicians, into a synchronized multi-angle video that the federal prosecutor would play for the jury, without commentary. Letting it simply run was unambiguous in every detail that mattered. Garrett pulled her arm with enough force to rotate her body. The motion was not a guidance, it was a yank, the difference made unmistakable by the physics of how her body responded. The forward stumble that was not a voluntary step, but a reaction to momentum that was not her own. Her face met the edge of the metal screening table. The sound was audible on the recording. Not a loud sound, a brief hard contact, the sound of bone and cartilage meeting stainless steel at a speed that left no room for adjustment. Her glasses shattered on impact, and a fragment caught the skin beneath her left eye, opening a cut that began bleeding immediately, bright red against the silver surface of the table visible on camera. Number 2 in the kind of detail that makes people in courtrooms look away. Her right shoulder was wrenched backward as Garrett maintained his grip during the forward motion, and the joint caught between 2 forces moving in opposite directions, separated partially. The pain was immediate and sharp and radiated from her shoulder down the length of her arm in a way that made it difficult to catch a full breath. Garrett planted his knee in her upper back and applied his weight. He was leaning down close, and the microphone on camera number 6 captured what he said next. 2 sentences spoken in the satisfied, unhurried tone of a man who believes with complete confidence that he is in a room with no consequences. He said the first sentence in the ordinary voice of someone stating a fact that has already been established, the voice of a man for whom this was not an incident but a routine, a pattern repeated so many times it had lost any sense of exception. He was not angry when he said it. He was not even particularly engaged. That was in certain ways the most damning thing about the recording. Not that he said it in heat or under stress, but that he said it the way a person says something they have said so often it no longer requires emotional investment. The second thing he said when Danny Mercer once again attempted to step forward and say something was directed at his partner. Not angry, not urgent, just dismissive, in the settled way of someone who had long ago decided that the concerns of junior officers were simply not part of the information he needed to process. "I know how to handle these situations," he said. 7 audio capture devices in the vicinity recorded the sentence. The plural of situations, not this situation, but these situations would be quoted verbatim in the federal indictment. He did not put the handcuffs on because she was resisting. She was not resisting. Every camera in the vicinity, and there were 9 of them, documented a woman who had kept her hands visible from the moment the encounter began, who had not raised her voice above a conversational level, who had not made a single physical movement that was not either instructed or involuntary. He put the handcuffs on slowly with the particular deliberateness of someone who was not hurrying toward a lawful purpose but savoring the exercise of something else entirely. He tightened them past what was necessary, a fact that the bruising on her wrists would confirm for the medical examiner who photographed them 40 minutes later, and that the jury would hear about from a use-of-force expert who had trained law enforcement officers for 22 years. Renee Caldwell's briefcase lay on the floor nearby. Her federal judicial credentials were still visible on the ground where they had fallen when the briefcase was knocked from her hand, the photograph facing upward, her face looking toward the ceiling of an American airport, while she lay face down on a metal screening table with her hands cuffed behind her back. Marcus Webb had been a civil rights attorney for 27 years before he retired, and in those 27 years he had handled 41 cases involving law enforcement misconduct, appeared in federal court in 11 states, and reviewed more security camera footage of police encounters than he could calculate. He knew what excessive force looked like from the outside. He also knew in the specific practical way that comes from having argued these cases for 3 decades what the difference was between an incident that became a case and an incident that got buried in an administrative process that produced nothing but a letter that said insufficient evidence to proceed. The difference almost always was documentation. He kept his phone up and steady, maintaining the angle, and he did not shout or rush forward in a way that might later be characterized as interference. Instead, he spoke loudly and with the carrying projection of someone who had spent a career making sure courtrooms full of people could hear him, identifying himself by name and profession, describing what he was observing in real time as though he were narrating evidence for a record that would be reviewed later, because he knew with complete certainty that it would be. He also dialed 911. He described what was happening in the specific, legally precise language of someone who understood that the words used in the initial report would shape every subsequent conversation about the event. An airport police officer is applying physical force to a restrained, compliant individual who is not resisting and has identified herself as a federal judge. The individual has visible injuries and is requesting medical attention. I am at Hartsfield-Jackson Atlanta International Airport pre-check lane 4, and I'm recording. Sandra Ortiz moved closer rather than further away, which was not the instinctive response for most people in the vicinity of that kind of scene, but which was the response of a woman who had spent 12 years regretting not having her phone out when her brother was stopped and questioned for 45 minutes in an airport in Cincinnati for no reason she or he could ever determine. She had not been able to do anything for her brother. She could do something now. Her footage captured a slightly different angle than Marcus Webb's lower wider, including the floor where Renee's credentials lay open, and also capturing the faces of the dozen or so bystanders who had stopped moving entirely, their expressions running along a spectrum from shock to recognition, to the particular, specific kind of grief that black travelers in particular seemed to carry in their faces in that moment. A TSA supervisor named Dolores Hampton heard the sound of breaking glass from across the checkpoint and moved toward it with the purposeful stride of someone who did not yet know what she would find, but knew that the sound of breaking glass inside a federal security facility was not something she could pretend she hadn't heard. She knelt, picked up the judicial credentials from the floor, read them, and went entirely still. Chief Roger Dunn was in his second-floor office reviewing staffing schedules for the holiday travel season when the first call came in from Dolores Hampton, whose voice carried the specific quality of someone who is trying to sound controlled while processing something that is making control very difficult. The second call came 40 seconds later from the airport authority's director of operations, whose voice carried no such attempt at control. The third call, 90 seconds after the second, came from a city council member who said without preamble, "Roger, there is a video already circulating on Twitter of something that appears to have happened in your terminal in the last 10 minutes, and you need to be in front of it in the next 5 minutes, or there is going to be no version of this you can manage." Dunn was already out of his chair before the call ended. He was not running toward the scene because he was appalled by what had happened. He was running because he understood with the calculating instinct of someone who had spent 20 years learning how to keep things quiet that this particular thing had already gotten very, very loud. He pushed through the perimeter of people who had gathered, not a crowd exactly, but a dense, silent cluster of travelers who had stopped being travelers and become witnesses, and what he saw first was not a person but a scene. The metal screening table with the dark mark on its surface, the shattered glasses on the floor, the scattered documents, the open briefcase on its sitting. Then he saw Renee sitting on a metal bench nearby. Her right arm held at the unnatural angle of a shoulder that has been forced beyond its range, a paramedic applying gauze to the cut below her left eye. And then on the floor, 2 feet from where the briefcase lay, he saw the credentials. He picked them up the way you pick something up when you are not yet sure what you are picking up, but your body has already registered that it is important. He looked at the photograph. He looked at the woman on the bench. He looked back at the photograph. Then he began reading. The first thing he read was the name. Renee M. Caldwell. It didn't land immediately. There are a great many people named Renee Caldwell in the world, and his mind had not yet made the connection. He read the next line. United States Circuit Judge, 11th Circuit Court of Appeals. The floor did not literally tilt, but something in Roger Dunn's body registered a shift in what was stable and what wasn't. the way your inner ear registers a change in elevation before your conscious mind fully processes it. He read the next line. Appointed by the President of the United States. Confirmed by the United States Senate. The color left his face with the completeness of a tide going out not gradually but all at once, leaving behind a pallor that one of the bystanders would later describe in her statement to investigators as the look of a man who has just opened a door he cannot close again. He looked up at Renee on the bench. She was looking at him with an expression that he would later describe in his own statement as like, "She knew exactly what I was thinking and had already decided what she was going to do about it," which was, it turned out, an accurate read of the situation. He looked at the 9 cameras. He looked at the people with phones. He looked at the open briefcase and the scattered documents and the blood on the screening table. And then he turned to look at Thomas Garrett, who was standing nearby, with the loose, satisfied posture of a man waiting for his chief to tell him he had done good work. And Roger Dunn looked at him with an expression that Garrett had never seen on Dunn's face before. An expression that took Garrett several seconds to identify as something close to terror, and several more seconds to understand was not terror of the situation. It was terror of him. Garrett walked over and began explaining. He used the language he had used 34 times before when supervisors had come to check on his work. Calm, organized, sequential. Non-compliant. Possible security threat. Refused lawful orders. Had to use necessary force to detain. Dunn was not looking at him. Dunn was looking at the credential in his hand, then at the cameras, then at the 24 people with phones, then at Renee on the bench, and then back at the credential, cycling through all of these things in the way a person cycles through an inventory when they are trying to calculate whether there is any version of the next few hours that does not end in catastrophe. Garrett stopped talking. In his 17 years working for Roger Dunn, he had never seen Dunn not respond when he finished a sentence. The silence that followed the end of his explanation was a different kind of silence than he had encountered before, and something in the back of his mind, some animal part that had been dormant for 17 years of consequence, free behavior, began very quietly to sound an alarm. Dunn said 4 words very quietly without looking up from the credential. "Take the cuffs off." When the handcuffs came off, Renee Caldwell stood up from the metal bench slowly and with complete intention. Not quickly, not urgently, not in the way of someone who is relieved, but in the way of someone who has been waiting for this exact moment and is choosing to inhabit it with every ounce of the composure she had spent 56 years building. She took her credentials from Dunn's hand without a word. She smoothed the front of her jacket with her left hand, the right arm still hanging wrong, the shoulder still hot with pain, and the gesture was small. But it said everything it needed to say. I am still here. I am still who I am. Nothing that just happened has changed a single fundamental thing about me. Dunn opened his mouth to say something that began with, "Your Honor, let's get you somewhere private." She looked at him. "Chief," she said, and her voice was level and clear and carried across the quiet of the terminal in a way that everyone within 30 feet could hear perfectly. "I have spent 24 years prosecuting cover-ups, and I know exactly what the sentence you just started means. I want to remind you that you are on 9 different cameras right now, and that whatever you say next will be part of the record." She looked at the credential in her hand and then back at him. "I'd like to speak with the FBI, please." The paramedics wanted to transport her to Grady Memorial Hospital immediately. The shoulder needed to be properly reduced. The laceration beneath her eye needed suturing, and they were professionally extremely uncomfortable with the idea of a patient sitting on a metal bench in an airport concourse because she had decided that leaving was not yet appropriate. Renee understood their concern and declined to be moved. She allowed them to stabilize her shoulder in a temporary sling to close the wound with a series of butterfly closures that would hold until she could get the stitches she would eventually need, and to take her vital signs, which were by all measurable indicators the vital signs of a person in considerably less distress than the situation they were in might have suggested. She made one phone call which she placed herself to her judicial assistant and which lasted less than a minute. "I am well. I am at the airport. Please notify the Chief Justice's office that the hearing will need to be rescheduled. The reason will be apparent within a few hours." She paused. "No, I am not in danger. I want to make that clear. I am fine." When Dunn attempted to suggest that the situation could be resolved internally, Marcus Webb, who had not moved from his position 15 feet away, phone still recording, said loudly enough for everyone to hear, "Chief, I want to note for the record that you just attempted to discourage a federal judge from contacting the FBI following an assault in your jurisdiction. I would strongly recommend against continuing that line of conversation." Dunn stopped talking. Two special agents from the Atlanta field office arrived at 23 minutes past 8. They did not arrive with visible drama. No tactical gear, no sirens in the final approach. Just two people in dark suits moving through the terminal at a pace that communicated seriousness without spectacle credentials, out and visible before they had fully cleared the security perimeter. They spoke with Renee first, briefly, and then they issued a subpoena for the full security camera archive for pre-check lane 4 and the surrounding area effective from 6:30 that morning through the present moment. They did this as a matter of standard procedure, and they did it before speaking to Dunn or Hollis or Garrett, which communicated to everyone present a very clear set of priorities. Garrett's incident report had been filed at 10:52 that morning, 40 minutes before the FBI arrived. It stated that the subject had approached the pre-check lane without proper verification, had been non-compliant with lawful instructions, had become verbally combative, had refused to produce identification when requested, and had physically resisted during the attempt to detain her. The FBI agents received a copy of this report. They also received the subpoenaed camera footage. The two items were then placed side by side, and the comparison began. The forensic video review that the FBI technical unit conducted in the weeks following the incident produced a document that was in its way one of the more devastating pieces of evidence in the entire case, not because it contained anything surprising to anyone who had simply watched the footage, but because of the meticulous point-by-point manner in which it walked through each claim in Garrett's incident report and demonstrated with specific time codes and camera references precisely where each claim departed from what actually happened. Subject approached pre-check lane without proper verification. Camera, 3 times. Stamp, 7/38/14. Subject extends federal credentials to Officer Garrett. Garrett looks at credentials for 1.3 seconds. Garrett does not scan barcode. Garrett does not examine seal. Garrett redirects subject to secondary screening. Time elapsed between credentials presentation and dismissal, 1.3 seconds. Subject refused to produce identification when requested. Camera, 1 timestamp, 7:39:02. Subject is holding open credentials in her left hand at the time this alleged refusal is documented. Subject physically resisted during detention. Cameras 2, 4, and 5. Simultaneous view. Subject's hands remain visible and still from the moment of initial contact through the application of handcuffs. Zero movement, consistent with resistance. The report was wrong on every checkable point. And then there was the body camera footage. Thomas Garrett had submitted a written notation with his incident report, indicating that his body-worn camera had experienced a technical malfunction and had not recorded any footage of the encounter. This was by that point a sufficiently common occurrence in police misconduct cases that the FBI technicians had a protocol specifically designed to address it. Retrieve the device, access the manufacturer's cloud backup server, and recover whatever had been uploaded before the claimed malfunction. The footage was there. All of it. Including the 2 minutes before Garrett had ever approached Renee Caldwell. It showed him standing near the pre-check entrance watching the incoming crowd turning to say something to Danny Mercer. The audio was clear. The sentence was 5 words. "Watch me handle this one." His voice when he said it was not angry. It was not tense with professional alertness or heightened by any reasonable suspicion of a security threat. It was relaxed, almost cheerful. The voice of a man who had just decided to do something he found on some level enjoyable. That 5-word sentence would be played in a federal courtroom on a screen 12 feet wide 7 months later, in front of a jury of 12 people who would hear it once and never forget it. The federal grand jury convened on the first Monday of December, 6 weeks after the incident in a courthouse in downtown Atlanta, and the proceedings lasted 4 days, which, for anyone familiar with the pace of federal grand jury investigations, communicated something significant about the strength and organization of the evidence the government had assembled. The indictments came down on a Thursday morning and covered 4 individuals. Thomas Garrett was charged with assault under color of law pursuant to federal civil rights statute conspiracy to deprive a person of civil rights making false statements in a federal report and obstruction of justice. The potential combined sentence, if convicted on all counts, exceeded 25 years. Ray Hollis was indicted as a co-conspirator charged with conspiracy obstruction and failure to prevent a federal crime he had been positioned to prevent and had chosen on 34 documented prior occasions to allow instead. Roger Dunn was indicted separately for obstruction of justice and attempted witness intimidation based on his actions at the scene and on a recorded conversation between himself and a departmental attorney in which he discussed methods of managing the narrative before the FBI arrived. Danny Mercer was granted immunity in exchange for full cooperation and complete testimony. The Thomas Garrett, who appeared for trial in the federal courthouse in Atlanta 7 months after the incident, was a different physical proposition than the Thomas Garrett who had stood at the pre-check entrance at Hartsfield-Jackson on a Tuesday morning in October, though the differences were subtle in a way that was in itself telling. He was wearing a suit that fit the way suits fit when they are purchased for a specific occasion, rather than worn regularly. Slightly off in the shoulders, slightly long in the sleeves, the suit of a man whose professional life had not until recently required him to own one. He was thinner than he had been in the drawn-down, depleted way of a person who has spent 7 months sleeping badly. His posture, which had been one of the most immediately notable things about him on the security footage, that wide-legged, settled proprietary stance, was gone entirely, replaced by the careful, compressed stillness of someone who is aware of being watched and is trying to manage what being watched reveals about them. He still believed at the start of the trial that he would be acquitted. His attorney had told him that police use of force cases were difficult to prosecute, that juries were traditionally sympathetic to officers, that the government had a high bar to clear. He had held on to these things the way a person holds onto a railing on a ship that is going down. The prosecutor, a federal attorney named Constance Reeves, who had tried civil rights cases for 19 years and had the particular economy of manner that comes from knowing that good evidence does not need to be oversold, played the footage on the first day of the trial without extensive preamble. She played it from camera 5 first, the angle that showed Renee's hands clearly visible and still for the entire duration of the encounter. Then she played it from camera 2, which showed the moment of contact with the table and its immediate aftermath. Then she played the body camera footage from the beginning, including the part that Garrett had claimed didn't exist. "Watch me handle this one." She let the footage run in the room for a moment after it stopped. Then she said, "Ladies and gentlemen, you have just watched Officer Garrett describe what he was about to do as something he knew how to handle. He then went and did it. The question the government asks you to answer is not complicated. Is what you just watched consistent with the incident report that Officer Garrett filed? And is what you just watched consistent with the lawful exercise of police authority?" She sat down. The jury had been watching the screen. Several of them were still looking at it when she sat down, even though it had gone dark. She testified for 3 hours on the second day of the trial, walking through the sequence of events with the methodical precision of someone who had spent a professional lifetime presenting evidence, and the jury listened with the specific quality of attention that people pay to someone who is clearly telling the truth and knows exactly how to make the truth legible. At the end of her direct examination, the prosecutor asked her one final question. "Judge Caldwell, can you tell this jury what was going through your mind during those 11 minutes? Renee was quiet for a moment. Then she said, "I was thinking about the 847 people who had filed complaints before me in cases that went nowhere, against officers like this one, and I was thinking that they had gone through something worse than what I was going through, because they didn't have a 24-year record of federal prosecution standing behind them. And I thought this time the record is going to matter. The courtroom was silent for a long time after she finished speaking. The jury deliberated for 7 hours across 2 days, not because the evidence was ambiguous, but because they were thorough, because several of them wanted to be certain they had looked at everything before they decided, because the gravity of what they were deciding deserved the time. The verdict on all counts was unanimous. Guilty. At sentencing, the federal judge addressed Thomas Garrett directly and at length before announcing the sentence, speaking about the specific nature of the betrayal involved when a person entrusted with protecting the public uses that trust as a weapon against the people they were sworn to protect, and about the particular damage done when the mechanism designed to catch and correct that kind of betrayal is itself corrupted by the same people who are supposed to operate it. Thomas Garrett received 9 years in federal prison, permanent lifetime ban from any law enforcement capacity, full forfeiture of pension and benefits. Ray Hollis received 3 years. Roger Dunn received 2 years and forfeiture of pension. As the marshals moved to take Garrett from the courtroom, he turned and looked back once, the specific, involuntary look of a person searching for something they aren't going to find. Renee Caldwell did not look away. She held his gaze with the same steadiness she had maintained through the entire 11 minutes at the airport. Not angry, not triumphant, not performing anything for anyone in the room. Just present, just clear, just the same woman she had been at the pre-check lane and at the prosecutor's table for 24 years before that, and at her kitchen table in Greenville as a child. She had promised herself a long time ago that she would never let the people who tried to diminish her have the satisfaction of her looking away. She didn't look away. 3 months after the criminal convictions, the city of Atlanta made an offer. It was a substantial number, $7 million, and it came attached to a non-disclosure agreement that would have prevented Renee from discussing the specifics of what had happened. The settlement terms, or the departmental failures that had allowed Garrett to operate unchecked for 17 years. She declined. Not the money, the silence. She said through her attorneys that she would accept a settlement that included 4 non-negotiable components: a full public acknowledgement of wrongdoing by the department and the city, a complete overhaul of the complaint review process with civilian oversight, the reopening and proper review of all 34 prior complaints against Garrett, and the establishment of an independent monitoring body with genuine authority to investigate misconduct without departmental interference. The city said no to the terms. The trial proceeded. 3 weeks of civil proceedings produced a record of institutional failure that went beyond Thomas Garrett and beyond the airport police department and reached into the administrative structures of the city itself. The ways in which a complaint process can be designed, not through any single malicious decision, but through years of accumulated choices about staffing and oversight, and what gets prioritized to produce outcomes that look like negligence, but function like policy. 847 formal complaints had been filed against Atlanta airport police officers in the 10 years preceding Renee's case. 93% of those complaints involved passengers who were Black or from other minority communities. Not one complaint had been sustained. Not one officer had received formal disciplinary action as a result of a traveler's complaint. An expert witness in organizational behavior testified that the probability of those numbers occurring by random chance, absent some deeply embedded pattern of discriminatory application of authority, was statistically negligible, less than a fraction of a single percent. The jury understood what that meant without needing the mathematics explained any further. 19 former victims of Garrett specifically came forward to testify, not as a group but individually, one at a time, each telling a specific story on a specific day. Each face added to the record of what 17 years of zero consequences actually looks like when you count the people it touches. The civil jury awarded $18.7 million, the largest civil rights verdict against an airport police authority in American history at the time of the ruling. The city did not appeal. The settlement terms, in addition to the monetary award, included every structural requirement Renee had originally demanded, plus a 10-year federal consent decree requiring Department of Justice oversight of all complaint procedures. The Atlanta Airport Police Department was disbanded and rebuilt from the ground up under new leadership, with new hiring criteria, mandatory training in use of force standards and implicit bias, and a civilian oversight board with actual investigative authority. Renee used a significant portion of her personal settlement to establish the Caldwell Access Initiative, a nonprofit providing free legal representation to victims of racial profiling at transportation facilities, airports, train stations, bus terminals. In its first year, the initiative took on more than 180 cases across 20 states. Danny Mercer resigned from the Airport Police Department 2 weeks before the criminal trial began. He gave full testimony not because he had been courageous on the morning of October 14th, but because he had made a decision in the months that followed, that he was not willing to let his silence on that morning be the thing that defined what he did next. He enrolled in law school at night, working days in a legal aid office. He sent Renee a letter before his first semester began, which she read once and kept. She wrote a letter of recommendation that did not excuse what he had failed to do but spoke clearly about what he had chosen to do when choosing had become genuinely difficult. Sometimes the most honest thing you can say about a person is that they got there late and they got there anyway. Hartsfield, Jackson, Atlanta. International Airport. A Wednesday morning in December, 2 years and 2 months after the morning that changed everything. The holiday travel season had just begun, and the terminal was full in the particular dense, purposeful way of airports in mid-December. Families with too much luggage, children running in small circles around parents who were simultaneously checking boarding passes and managing everyone's coats. The low, steady roar of 10,000 separate itineraries converging on the same set of gates. Renee Caldwell moved through the pre-check entrance at 7:25, which was exactly when she had planned to arrive because she still planned her airport arrivals down to the minute and probably always would. The credentials were in her briefcase. The navy suit was pressed. There was a small photograph of her father in the interior zip compartment, the same photograph that had been there the last time. A TSA officer glanced at her boarding pass and waved her through. Nobody stopped her. Nobody asked her a question she hadn't been asked for a reason. Nobody looked at her face and decided in 3 seconds that she needed to be checked. She walked to the place where the old screening table had been. The area had been redesigned and the renovation that followed the department's dissolution opened up, made lighter, and she stood there for a moment, just a moment, and let herself be in it. She thought about her father in his Sunday suit at her graduation, his expression saying everything without saying anything. She thought about Calvin Price's mother in the corridor outside a Georgia courtroom holding her hands. She thought about a woman she had never met and would never meet who was walking through pre-check lane 4 right now with her shoes still on without being stopped, and who would get on her flight and arrive at wherever she was going, and would never know that the ease of that passage had cost something significant to make possible. A woman moved through the lane beside her. Black, probably in her early 40s, rolling carry-on earbuds in, moving at the efficient pace of a regular traveler who had learned the choreography and was simply executing it. She passed through the scanner, collected her bag on the other side, put her laptop back in her case without looking up. She didn't look around to see if anyone was watching her. She didn't check the way Renee had always checked, and the way so many people still checked that quick peripheral scan to see whether the posture of the officers nearby suggested they had noticed you in the wrong way. She just walked. Renee watched her go, and something in her chest that had been carrying a specific kind of weight for 2 years released a small but measurable amount of it. It was not the $18.7 million that mattered. It was not the 9 years Thomas Garrett would spend in a federal facility. It was not the disbanded department or the consent decree or even the Caldwell Access Initiative and its 180 cases across 20 states, though all of those things mattered enormously and were worth every hour of every year it had taken to make them real. It was a woman in her 40s moving through an airport on a Wednesday morning in December, not looking over her shoulder. One airport, one lane. One morning where that one thing was true. Renee Caldwell picked up her briefcase and walked toward her gate. There are moments in life when a system, any system, a company, a department, an institution, a room, looks directly at you and decides that you don't exist in the way you know you exist. And those moments are designed, whether consciously or not, to make you accept that verdict, to make you small enough to fit inside someone else's idea of what you should be. What happened in that Atlanta airport 2 years ago was one of those moments. And what Renee Caldwell had spent her entire career understanding from her father's kitchen table in Greenville to the federal bench was that the verdict only stands if nobody challenges it. Sometimes the person who challenges it is a federal judge. Sometimes it's a retired attorney with his phone out standing 15 feet away. Sometimes it's a high school teacher who remembered that she didn't have her phone out once before and decided she would never make that mistake again. All three of them were necessary. All three of them mattered equally. If this story stayed with you, if you saw something in it that felt true about the world, you know we'd ask you to share it with someone who needs to hear it and to subscribe to our channel so you don't miss what comes next. The stories that matter are the ones that remind us what accountability actually looks like when it finally arrives.